Podcast is now starting. All attendees are in listen-only mode.
Testing 1, 2, 3. Testing. Okay, good evening and welcome to the Micklin Law Group's monthly webinar series. This month's webinar is Defending Against Bogus Allegations of Domestic Violence in Divorce Cases. Actually would apply to domestic violence really in any case, but we're a divorce and men's rights law firm. My name is attorney Brad Micklin. I'm the managing member of the Micklin Law Group. We have offices in Nutley and Montclair, and as I briefly mentioned, we are concentrated in men's and fathers' rights in divorce, custody, and family law issues. Again, I'm going to give 1 second to let people sign on to my webinar page, and then I'm going to just start going through each slide. Okay, so real quick, let me give you a little background about myself for those that might be watching that haven't worked with me. This is me, if you're watching the PowerPoint. Again, my name is Brad Micklin. I'm a member of the New Jersey State Bar Association. I'm licensed to practice in both state and federal courts. I started my career with a law clerk, judicial clerkship with the Honorable Eugene Austin, the Special Civil Part of Bergen County. After that year, I went and did complex commercial litigation with Kessler & Associates for a number of years. And then I realized I didn't care much for representing businesses, and I went into my own practice about 20-something years ago now. Originally, I started as a general practitioner, which means I did a little bit of everything, and quickly found you can't be good at everything. You can only dabble, so I decided to concentrate and build a practice in divorce, family, and custody matters. Recently, we've now focused more into men's and fathers' rights. Not that we don't assist and help women, but we do believe the more focused, the better representation that you can get. Moving right along, here's a list of some awards, accolades I've been honored and fortunate to receive in the past. I don't put these up to boast or to impress you, but to impress upon you that I do have a great deal of experience. I care a great deal about what I do, and I believe I have a good deal of history and can impart a lot of wisdom and assistance to those that are watching. All right, a little technical problem. For some reason, I shot back several. Okay, so let me first, before I jump into this, remind those that are watching, or at least tell those that are watching, I also do sponsor a divorce and custody support group. It's the last Wednesday of every month. It's in my office in Nutley at 187 Washington Avenue. It's open to all people, clients, past and present, consults, people that are contacts. It's not a legal matter. It's just a support group for those that need somewhere to talk about this. Like I said, so it's 6 to 7. I think the last one was actually just yesterday, so it's not going to be for another month, but the dates are always on my website. So let's move along and talk. Wait, I'm going to pause the video for a second because something keeps happening and moving my PowerPoint back, and I don't know why. And I don't want people that are watching this to get frustrated. Don't see anything that's open, so I'm just going to jump right back into the PowerPoint. I'll deal with it, and hopefully there won't be continuing problems. I just don't know what that was from. It's the second time it shoots me back to the very beginning. Never had this happen, but I hear a beeping sound whenever it happens, so I'll probably just try to move a little faster so that you don't have to get tied up in all this delay. So quickly, what are we going to cover here? First, we're going to talk a little bit about what a restraining order is, who would qualify for it, the different actions or laws that are covered and violated and sort of punished for doing so, the relief that you can seek, the problems where some people use it as it's intended as a protection, but others use it as a sword, which is sort of what the focus of this is going to be about. Challenging false allegations of both physical and emotional abuse, how a bogus restraining order can affect a divorce case, some of the complexities that you'll deal with in domestic violence cases. I'll also talk about its impact on your civil and your parental rights. Then lastly, some steps to take when you have been falsely accused. Let me take 1 second because this is being broadcasted in September of 2018, so I don't know when some people may be watching it, but it's right in the middle of the Kavanaugh confirmation hearings and the rising Me Too movement. Don't want to make this a political statement. I certainly don't want to make the webinar political. It's not about people that are all making false restraining orders. Like everything, I think there are good and bad people. There are good and bad things. And this is to address the small piece of those that are without merit. Moving right along, let's first talk about what a restraining order is. I think it's helpful to understand it before we can actually talk about defending against it. So first part of a restraining order process is the temporary restraining order that gets entered either by the police department in the evening or the family court during the day. It is generally granted very, very easily. I've often spoke of it as like getting candy on Halloween. It's not very challenging. Even when it seems evident on the face of the allegations that it does not qualify as domestic violence, many still do receive a temporary order. Judges tend to err on the side of caution. Then there's the final restraining order, which comes after a trial, generally after a trial. Sometimes there's consent, but usually not. It is considered permanent. New Jersey and I think Washington are the only states that actually consider restraining orders permanent. The thing about it is technically, even though they call it permanent and say it's permanent, it's really not. You can seek to dissolve it. You need to file a motion before a superior court judge. And it can't be within 1 year of receipt of the final order, but there technically are ways to dissolve a final order. Both temporary and finals will generally restrain all types of contact between you and the complaining party, and often children involved in the family and any other third parties that the person seeking the restraining order feels needs to be protected. Children will often be either limited completely with no contact or at least limited communication. Violations of either one are criminal. If there's more than a benign violation, like an accidental text message that gets sent, it will be prosecuted like a criminal matter. The evidence standard for receiving a final order is what's called a preponderance of the evidence. It's not a reasonable doubt standard like you'll get or hear about in a criminal case. It's a much lower threshold. Preponderance is sort of more likely to be true than not, probably one of the easier ways to explain it. But it's not beyond a reasonable doubt, and which is why they're quite common. Now let's talk about who's going to qualify for a restraining order. This is important because, and take note, depending on when you're watching this, the laws have been expanding a great deal. So let's just talk about where the law is and some of the recent changes so you know what to expect. First of all, obviously spouses, not obviously, but spouses are covered. Former spouses are covered. If you have a child with a person or a dating relationship, any relative, and then it's been expanded to a present or former household member. I don't know actually if that portion has been expanded, but the definition of it has over the past decade or so. The trend has been to broaden the scope to provide more protections to victims of domestic violence. I've seen cases where landlord relationships have been subject to restraining orders. In the past, it was generally some type of intimate relationship, some type of family or romantic relationship, but the trend has slowly been to increase that to other groups. Let's talk about the acts that are covered under the Prevention of Domestic Violence Act. I'm not going to go through a great deal of time. I'll list each one, and they show on my PowerPoint. And then I'll cover the ones I think are the most important. And this is important to understand because you cannot get a restraining order, a final restraining order, unless you can prove two things. One, that one of the acts I'm about to mention have been violated. And two, that because of the violation or the past history, that you need the long-term permanent protection of an order. So understanding what's being alleged to have occurred is very significant. So let me just go quickly through them so that doesn't take up the whole webinar, just going through. Homicide, assault, terroristic threats, kidnapping, criminal restraint, false imprisonment, sexual assault, criminal sexual contact, lewdness, criminal mischief, burglary, criminal trespass, harassment, stalking, and a recently added cyber harassment. I'm going to attempt here on the PowerPoint, I'm circling harassment, stalking, and cyber harassment. These are the most common ones that you will see. They are, let me go back. They are the most commonly itemized or listed in a restraining order. I think it's also because they're the easiest, for lack of better words, to commit in an intimate relationship. Cyber harassment is new. Like I said, it's to cover text messaging, social media, and all the new developments in the kind of communication. The one thing I want to quickly point out that a lot of people are confused by under harassment and stalking quickly is that installing a GPS in many cases has been found to be, in most cases actually has been found to be an act of domestic violence leading to a restraining order. And I say that because there are a lot of people who don't realize that and actually do this when they're in a troubled relationship, especially a divorce case, because they're trying to find out where the person is. Don't do it. I had a case where I advised a client not to do it. He did do it. She filed a restraining order. Fortunately, we were able to have it dismissed. The judge did not find it rose to the level of domestic violence, but I got to tell you, the case law was entirely against it, and we were fortunate that it worked out. So I make sure to tell everybody, don't do it. It may not seem like it because you're not there, and he or she won't know about it, but it is. So you want to review these, and if you have one filed against you and you're not going to be hiring a lawyer for it, read what the statute says about these different actions. They each have a certain intent and a certain conduct that has to occur, and they have to prove that this actually occurred. So you need to know what needs to be proven by the other party so that you can properly defend yourself against it. All right, so let's talk about what you can receive or what kind of relief you can obtain under a prevention of domestic violence temporary or final restraining order. Everything I'm about to mention can be granted in either a temporary or a final restraining order. The reliefs can be identical. And just because you ask for one thing in a restraining temporary doesn't mean you can't ask for it in a final, and vice versa. First, you can ask for the arrest of the defendant. That's usually going to be done by the police department prior to, or not prior to, at around the same time of the issuance of the temporary, but it's not usually at the complaining victim's request. It's usually based on the type of act and whether or not there's injuries, that you can request it. You can and will usually have the defendant removed from the home if you're sharing a residence. You will get an immediate restraint on all contact and all third-party contacts, meaning children. There usually won't be any contact with the children, relatives, your friends, co-workers, and significant others. This means not only can you not contact those people, but you can't even contact those people or you can't pass messages through third parties, but you're also prohibited from contacting them at all. Now, technically, it's about not contacting them for the purpose of harassment or some act that would violate the order. But that's hard to interpret. So my general advice is don't have any contact whatsoever with anybody that's closely related to and likely to take your information back to the plaintiff. Even if it's benign, even if it wasn't intended by you to get to her or him, it's going to be possibly a violation. So don't do it. There will often be distance restrictions, 1,000 feet from the house. Sometimes there's school events and things like that, that you can ask for there to be limitations if they're coming up. And this is important to understand. The contact or the relief that's granted is significant because restraining orders are supposed to be heard within 10 days of being granted, because all the relief that I just mentioned is very severe and is very swift, happens at any time during any day, and as soon as you're noticed, the other person's restrained and out of the house, away from the children and whatever else was granted. Now, it's supposed to be a return date in 10 days because it's such a swift, harsh restriction, but it often doesn't occur in 10 days. If there are going to be lawyers involved, it's going to be usually adjourned 1 or 2 times and not completed the same day. I generally tell my clients it can go up to a month, sometimes even 2. There have been cases that have been even longer, but usually not much longer. Now, inside of those 2 months, sometimes there are ways to seek to alter the temporary relief, like for parenting time and contact, but that's difficult and challenging because often the restraining order that was entered, the temporary, was entered by a different judge than the one that's hearing your final, and he or she may be reluctant to change the temporary restraining order. So you might be sort of married, for lack of better words, to the relief that's entered for a couple months. So you need to be prepared for what you're going to deal with. This is also significant for those that are running a business out of the house and then they're suddenly and swiftly removed from the house. You may need to make arrangements through the police department to get your personal items out of there. All right, a little more about the relief that can be received. In addition, there will be certain location prohibitions. You can't obviously go back to the house that you're removed from or the residence. Usually there will be a workplace Often it's your children's school or special events, especially under a temporary order. Temporary orders will often have much broader protections so that they can safeguard the plaintiff until you get to a final hearing. So you may have broad location protections, especially when it comes to children. There can and should be some kind of financial support. Not quite common in a temporary. People just don't think to ask for it a lot in temporaries, but it's very common in a final restraining order. It can be either direct pay to the plaintiff through mail without any other communication, or through third parties, or directly to the vendor like a mortgage or a utility company. You cannot send support payments directly to the plaintiff without a court order compelling you to do so, because just like the third party contact, it can be possibly construed as a violation, and you don't want to take any chance. They will confiscate firearms and other weapons. They may order a risk assessment. Now, there are several types of risk assessments. They could be substance abuse evaluations for drugs and alcohol, psychological evaluations for mental issues and parenting issues, and batterers intervention programs to deal with violent issues. More often than not, risk assessments are issued in the final stages or with a final order, but not during a temporary. There will be some expenses that can be ordered both in the temporary and the final, but usually more often, again, in the final. There will be fines and penalties. There may be some court costs. Usually they do the minimal fines and penalties. Their statutory range, I don't know offhand what they are, sorry, but they usually make them the lowest, like $50 or something like that. Restitution, if there was any kind of cost damaged or cost resulting from the damage of whatever occurred. There could be damage to property like a cell phone or a car or a residence. Reimbursement for out-of-pocket expenses if there were things that had to be repaired, medical bills, and then counsel fees. Interesting thing about counsel fees, if you're defending on what you believe to be a bogus one, you may incur substantial counsel fees in defending against it and hope that at the end you would seek and receive a counsel fee award. I want to take a quick second to apologize. I think when I jumped back online, the show screen I forgot to put on, and the attendees were watching a blank screen. So I'm sorry. Hopefully it wasn't that long. I think it was only a few minutes that I went back off, but you should be seeing it now. So going back to counsel fees, if you make the request against a bogus one that is dismissed, you won't be able to get your attorney's fees, even though it would seem like that's a fair and reasonable request, because the case is dismissed. And if there's no case, there's no way for the court to order anything. They're without jurisdiction or power to give anything, even if it was inappropriately filed. Now, turning to the issues that brought us here, the next slide for those that are watching on the PowerPoint is how restraining orders are used as swords instead of shields. First, they're often used when there is going to be or is other litigation pending. They will use it often for custody issues. A final restraining order will carry with it a presumption that the recipient should have sole physical custody. So that is often a driving, not often, but can be a driving force when it comes to a bogus restraining order. Equitable distribution of a house and other property. Now, I'm not saying that a restraining order does lead to these things, but these are some of the reasons why a person might either bolster their allegations or seek one that is without merit. A lot of times parents are looking to curtail communication with children. There's unfortunately a lot of alienation efforts in these kind of high conflict matters. It will give them the right to unilateral decision making, especially during the temporary order. And like I said, it can be several months before you get to a final order, and it's an effective way to limit contact. It can affect employment opportunities, especially if you're a police officer or security guard, because you lose your ability to carry a weapon. The final one will be registered and accessible in certain employment searches, so it can be a hindrance later. Sometimes it's a tactical choice to get this. There will often be restrictions on travel, especially if it's a final order. You will often be detained on, I know at least international flights. I'm not sure about domestic, because they need to make sure that the plaintiff isn't anywhere close by. So they will restrain and hold you until that determination can be made, often a very long time. It's problematic. You will be prohibited from carrying firearms. So like I said, that can affect not only your employment, but a lot of people collect firearms, use it as a hobby, and that can impact that. Your name is entered in a central database so that wherever you go, at least in New Jersey, I think it's only limited to Jersey right now, that they can punch up and find out that you are in a final order and subject to that control, so that anywhere in New Jersey that can be enforced. You will be fingerprinted. A lot of people are embarrassed by it. I mean, it's certainly not a pleasant experience. And if you're going to be arrested, you don't know where that's going to happen. It could happen at the workplace. It could happen in front of your children. And sometimes that's part of the leverage motivating a bogus or meritless claim. Seeking to get leverage in a divorce that is or may be coming. Again, not that it's going to, but that people think it will, because truthfully it doesn't. And lastly, it's often used to get people out of the house. I mean, I've seen restraining orders that say, I've been trying to get him or her out of the house, and they won't go. And it's obvious the intention behind it. It's probably the most common one that I see when they don't have merit, is because they wanted them out of the house. Usually there's relationship or marital problems, and that was the quickest solution. All right, so moving on. So what can you do to challenge false allegations of physical or emotional abuse? First is consider whether you're going to file your own criminal complaint or a reciprocal restraining order. This is always, in my opinion, if you have the basis, a very effective remedy. And the reason why I say if you have the basis, quite commonly, if we're talking about bogus restraining orders, either there's nothing to the allegation or it was a sort of reciprocal problem, meaning it was a fight or an argument. Two people fight, it usually takes two people to fight. Often we'll get one person who is attacking another, and when that person tries to defend him or herself, he or she is the one that gets the restraining order issued against them because they pushed the other person away and that person was bruised. So you will often have a basis to file your own restraining order. Now, real quick, I also hear a lot people are reluctant to do that when a temporary has been filed for reasons that, like, it's the parent of my child. I hear that from many of the men I represent. Oh, it's the mother of my child. I don't want to do that. And I can understand that. But the problem is, in this case, she did it to you if it's a bogus restraining order. And the reciprocal restraining order, if you have a basis for it, evens out the playing field and gives her possible reasons to reconsider going forward. There's a lot of remedies to resolve a temporary and a final restraining order that I'm not going to go into in this webinar. I have in others that are on my website, my YouTube page. I think it's titled Divorce and Domestic Violence. There are ways to remedy it, but if you're only one facing the charges, it's much more difficult to remedy that. How to avoid or challenge it? Limit all contact. I tell clients all the time when they're consulting with me for a potential divorce, I can tell when a potential domestic violence case is coming, even if it's merit or meritless. I can hear in the relationship as the tensions are rising that it's going to erupt. And when it erupts, this is what happens. And sometimes it's with merit and sometimes it's without. But if you can limit your conversations, limit your contact as much as possible, and if you're in New Jersey, record the conversations. I may touch on this a couple other times here. I'm not sure. I know I mentioned it in my other webinars about domestic violence and divorces. But if you're in New Jersey, because I don't know, not every other state allows you to record surreptitiously conversations. In New Jersey, if you're a party to the conversation, you can. If you have a spouse or a partner that is hostile and the tension is rising, I generally recommend that you start recording these conversations and limiting whatever contact you possibly can. Move. I hate to say it, but move out and live somewhere else. I know a lot of people either can't afford to, many don't want to leave their children because they're going to lose contact, and I get all of that. But if you get a restraining order issued against you, you're going to lose all of that anyway. better to be proactive and get out. Again, and I'm sure many of my colleagues can tell a person when that's likely to be coming and what to do. And if not, when it gets to that point, you make a phone call and you can find out. All my clients have my cell phone, and I'll tell people right away, get out, move out, go to your family's house, go to friends. You don't lose your children. You don't lose your right to the house in the divorce. It's just safer to get out. Keep contact electronic or in writing any way possible, whether it's text messages or emails, even paper letters that you keep a copy of it. Don't allow them to allege you said something that you didn't. You can always also, when you have these communications, I recommend that you upload them and store them somewhere, usually by category. I like OneNote and Dropbox. I tell a lot of my clients just create separate inboxes inside of your email so that you can slide emails in and out. Like if you have parenting problems and drop-off problems and arguments, you can slide your emails into these inboxes and then be able to access them depending on whatever issue you're defending against. Additional ways to prevent or challenge: keep your communications vanilla. And by that, I mean, don't say anything that you wouldn't want a judge to hear in the first place. Now, we all have somebody in our lives that push our buttons, and they're usually the people who installed them, who knew you the longest, so they know exactly where to go. But you don't want to ever say anything that you later have to explain to a judge, especially if it's on a voicemail or an email or a text. Don't send any angry text messages or emails. And don't lose sight of the fact that everybody around you has a recording device. I've been seeing cases all over the place where two people are talking and a third party was recording it, and it later comes out against that person. So you don't want to say anything that somebody else may even be recording. Always talk as if a judge is going to listen to it. Again, record these conversations. I use an app that's my favorite app. It's Rev, R-E-V as in Victor. I use it on the iPhone. It allows you to record one-touch recording. It records in the background, and I think even if you have a locked screen on, it also allows you to upload and send it places, and for a couple dollars you can have it transcribed if you need to use it in court. So it's a great app, and it's a great way to record your conversations. Pick up and drop off for children. Do it curbside or in a public place where there's some witnesses. I hate to say it, but you never know what's going to happen. You always want to make sure there are witnesses. You can consider a police station. That's a common pick up and drop off in a high conflict relationship. A lot of people aren't big fans of it because they think it sends a bad message to the children and can later sort of have them be concerned or not trust police officers because they were always involved when their parents were having problems. So I sometimes recommend maybe a fire station, firehouse, because it gives that show of authority, but it's not going to be traumatic to children. Okay, moving on. Hopefully you're taking some notes. Oh, by the way, the webinar that's on my on the GoToWebinar, and I think, I'm not sure when it gets posted or not, but right now it has the PowerPoints where you can download the slides. And you might want to download some of these if you're not taking notes so that you can remember things to do, because these are tips mostly for before you receive a restraining order. You want to prevent getting one, and the only way to do that is to watch and alter your conduct. So continue on. Next, keep a log, a diary, or some kind of calendar. Keep notes about what is or isn't happening. When there is and isn't pickups for the children, when there was a fight, what was it about? There are so many online resources now. Google Calendar is simple. You can go right into a date and just type in and plug in some notes. Countless phone apps that allow it to automatically synchronize to other places so you'll have it and you can access it. It is great. You can almost always use notes to refresh your recollection of what happened at a time that you don't recall. And if you have succinct notes with dates and times and conversations, it's going to be credible and it's going to be consistent with the testimony going forward. What happened before and what happened on a certain day is all consistent with that. It's believable. So it'll show if the claims that you're facing are not meritorious at all. Alert law enforcement when you think there's going to be a problem. Some counties and towns will have what's called a peacekeeping officer, where you can go and say, for instance, I'm going to pick up my children. We have a bad relationship, or I have a new partner and they don't react well. I'd like somebody to go and accompany me to make sure that there is not a problem. If there's a temporary order or final order in place and you need to get your personal items out, it's good to bring them along with you. Sometimes, and even if they don't have it, it's sometimes still good to say, going to my spouse's home for whatever reason, I anticipate there could be problems. I want you to know, so if we need to call for help, somebody would be, familiar with what's going on. It sort of deflates the situation when it occurs later. It may also show that you're kind of reasonable, level-headed because you addressed it first. So when you get to the door and there's a problem, the benefit of the doubt may fall in your favor. And use third parties for any communication when possible. Again, going back to my record conversations and say everything as if a judge is listening to it, you don't want to ever have anything come up against you or be misconstrued or twisted against you. So the best way to avoid that is simply to use a third party and not get in the middle of it at all. All right, so let's talk a little bit about what New Jersey does against a bogus restraining order. Let's say everything that I just suggested doesn't help and you find yourself on the bad end of one. Let me break the bad news to you. There's not much that they do when it is a bogus restraining order. And let me also point out, I'm not talking about orders that are dismissed because there's not a lack of proof or they didn't rise to the level. But, sorry, I just had to break on my screen. Hopefully I'm still going live here. They don't do anything. If I'm talking now, when I'm talking about how they handle bogus ones where it's clear that there was no basis for or it had some other purpose, New Jersey doesn't do really anything about it. And for all those officials and judicial officers listening to me, that's my opinion, like it or not. Even in cases where there's perjury, a client or a party will certify under oath to something either in a restraining order or in testimony, and it's later found to be completely fabricated, there's no consequence. It's unfortunate there's not, and largely because it's family court and they just want to kind of move the case along, and also the prosecutor can't deal with the volume that would come with it. So don't expect any support after them. Temporary restraining orders are overgranted. Like I said when I began this, it's like candy and Halloween. I could probably get one against anybody that's listening here by just, claiming something bad happened to me. And it's not that that's a bad thing necessarily, because the reason they're so easily granted now is because in the past, judges didn't grant them when they should have temporaries and people were injured and killed. So the pendulum has swung the other way to avoid that. The problem is we need to bring the pendulum back a little bit more, because now they're granting ones that you can even tell on its face clearly are without merit, or even if they were true, clearly don't qualify for the acts intended to be covered, but they grant them anyway. Final restraining orders, again, with the burden of proof I mentioned, the preponderance is simply more likely than not. It becomes a credibility issue. And in these kinds of circumstances, more often than not, there's not going to be a witness. It's an intimate relationship. It's usually inside closed doors without people around. So the burden of proof is not very high. So even when there's a question of whether or not to grant them, more often or not, they will lean towards it. There's rarely, like I said before, there's never any consequence to a bogus order. I mentioned earlier that if you can show that it was bogus and have it dismissed, you're unable to get legal fees because there's no case that exists any longer. It's a word conflict in the law that doesn't allow for any regress. A lot of times you'll want to get a psychological evaluation of the person who fought against you because of the nature of their conduct and the fact that they're taking such an aggressive posture. That too can't be granted because there's no order there. So you sort of lose all your power by being successful, which is ironic, but at least you walk out without the restraining order. You just can't get any further help from the court. So let's talk about some of the complex situations surrounding domestic violence cases and how you can deal with them. These are going to be just general common issues that you may face, and you want to be able to address them during and at a restraining order hearing. So first is to distinguish between domestic contretempt and domestic violence. Domestic contretempt is a common phrase that basically means people fight. People in relationships fight. And there's a whole slew of cases that say domestic contretempts are not domestic violence actions. Now, I'm sorry, on my PowerPoint, I think there's a spelling error. It says contretemps, it's contretemps. But it's a very powerful defense to admit, yes, Judge, we fought. I said bad things. I called him or her bad names. It doesn't rise to the level of domestic violence. Probably one of the most important arguments you can, because remember at the very beginning I said there's 2 steps to getting a restraining order: proving the act of domestic violence and proving that based on the act and history there's a need for a final protective order. So here you might admit you committed the act, but that the act is not so bad or the history is not so long as to suggest the need for a final and permanent protection. I just want to take a quick second to thank everybody. I see a bunch of people online. I'm simultaneously posting on Facebook and my YouTube page, as well as my webinar on my GoToWebinar page. So appreciate the support. I hope this is helping everybody. I will be available for questions both at the end of this and obviously anytime tonight and tomorrow. So turning back, another thing when you get into dealing with the complexities, a lot of custody issues, you always want to be able to argue that there's a balance between your rights to see your children and the plaintiff's rights of protection. Meaning, just because there are children involved doesn't mean that the need to give final protection over the plaintiff should in any way impede your ability to have a strong and powerful relationship with your children. Another thing to address and to realize is just because a child is in a family or in a situation where there is domestic violence, they may have even been present and involved in the domestic violence issue. You need to address excuse me, whether or not there was any actual trauma to the child or children by being a witness or being involved. Children are generally always considered victims of domestic violence if they're in the middle of a relationship that has domestic violence. But just being present doesn't necessarily mean the children were harmed. And the reason I'm pointing this out is it's difficult to stand in a court and make an argument like this unless you're ready for it and well versed in it. It's hard to say, yes, my children saw me strike his or her mother or father, but they weren't impacted by that, because they probably were. But depending on the situation, if you had an arguing match or you threw the phone and the children were downstairs, they probably weren't traumatized as much as they might be in other situations. And it's important to point that out, especially if you're on the opposite end of a final restraining order. Going back to some of the remedies I mentioned briefly before, you want to ask at a restraining order to pick up the children at the pick up and drop off at the police station. Now, this is a little different than what I said a moment ago about avoiding a restraining order. You can use third-party locations like a firehouse or a public place to avoid getting a restraining order. But if you've had what you believe to be a bogus restraining order that gets entered against you, because it's quite possible it will be entered against you because they're not hard to prove and there's never any witnesses, you don't want to put yourself in a position where that person who you claim lied to get the temporary order got a final order, because then they'll lie and claim that you violated the final order. So when it comes to the complexities and a final order, you don't take any chances and do pick up and drop off at police stations. Supervised parenting time is a common remedy. I don't usually recommend it for the person on the losing end of a restraining order because it's not enjoyable parenting time, but it is an effective way to avoid allegations of harm to the children. It also allows a third party to see your interaction with the children so that the person who obtained the restraining order can't later claim that you have or will be harmful to the children. And one issue you want to also deal with is that there's going to be problems with co-parenting, especially if there's a final order, because you can't communicate. And there's a presumption in a final order that the recipient receives full custody. So you want to address the difficulty you're going to have in co-parenting. You want to ask, for instance, that the order, whether it be temporary or final, be amended to allow some kind of written communication. And you might want to limit it to, urgent medical and other emergencies for the children. You might want to appoint a third person that can be the intermediary for communication, so that you're going to be able to communicate. You don't realize until you leave there that if you have a final order issued against you and you have children involved and there's no method for communication, you're going to have a significantly difficult time in staying in touch with your children and what's going on in their lives. And it may not get changed when you walk out of there if you go back to court any other time. Okay. Additional issues to deal with, and that is your rights. Just because you lost and received a final restraining order, and this is whether or not it's a bogus one or a meritorious one, you still have rights. You have the right to be informed about your children and their important decisions. You have the right to be involved in that. Now, I said in the beginning that a final order carries with it a presumption of sole custody, which carries with it a presumption that you don't get involved in important decisions. But in my experiences, judges don't actually grant that part of a restraining order. They're extremely reluctant to do so because the policy in New Jersey is that judges believe children benefit by having both parents involved. So they do everything they can to jump around that provision, and rarely will you see a restraining order specify sole custody. But you might want to address it and make sure that it's in the order, that you have to be involved in decision-making issues, or that there's joint custody. You want to make sure that you have the right to attend your children's activities and their milestones, like starting school and graduations and dances and proms. Again, when you get a final order and you walk out of court, amending in the future is not just a matter of saying, I want to change, but you have to show that there's been a material and substantial change of circumstances. And that's often very challenging. The passage of time and the growth of your children is not a material and substantial change of circumstances. So if you, for instance, get a restraining order when your child is 2, and then your child's going into kindergarten, that's not a change of circumstances. That was foreseeable. So you want to make sure that this is in a final order. You want to address it before it is completed. You want to make sure to protect your rights in equitable distribution of marital property. If you are taken out of your home or out of your business or accounts are frozen, you need to make sure that the final order and the judge issuing it will address that, because again, coming back another time to do so is very difficult. As I said, you're dealing with situations where you might work together. Obviously, you might live together, and you're going to lose possession of both the house and the business, and you need to address it as quickly as you can inside of the final restraining order if you're able to. All right, so let's talk about a little bit about what men can do to prevent civil and parental rights from being impacted. Now, a lot of this may be similar to what I was saying before, because it kind of my general belief about your rights are the same, whether it's parenting or civil rights, but we'll go through them anyway individually. So again, you want to recognize and point out to the court that you have a constitutional fundamental right to parent your children and to maintain a relationship with them, apart and aside completely from what you may have done to their parent. I'm not justifying what may be horrendous domestic violence. What I'm saying is that even if you are a person who committed that, that doesn't take away your fundamental right to parent your children. And you need to stand strong in court and indicate that, stand behind it. And judges will recognize it. Draw distinctions between the acts that are being alleged. I have on my PowerPoint, for instance, the difference of harassment and assault. Now, this is a very difficult thing to do if you're not with an attorney. And that is to try to argue it's not so bad, Judge. Domestic violence is always bad. And any act of domestic violence, whether it's a simple one act of harassment or all the way up to murder, it's horrible. But you have to be able to minimize that in some manner. You have to do it credibly, because I think deep down we all would admit there's a very big difference between an act of harassment and an act of murder. But you need to be able to say that carefully. Highlight whether or not your children were involved. As I said before, children are generally considered victims of domestic violence, whether or not they're present. But the level to which they're victims and the levels to which they're impacted will vary from case to case. And if you have a case that your children weren't impacted, you need to make sure that that's very clear. As I mentioned before, you're going to likely be ordered for different assessments like psychological and risk assessments. You may want to get your own evaluations. not usually before a restraining order is issued. They're of little use by the court, but you might want to get some afterwards, even if you're court ordered to attend your own risk assessments or psychological evaluations. It's nice to have your own independent evaluations. Nothing wrong with getting extra counseling or extra services. It shows the court that you're taking your matters seriously and addressing whatever issues the court may find that you have. For instance, you're ordered to go to the county domestic violence program. You'll find it's probably like 6 courses. You sit in a room for half an hour. Or a psychological evaluation through the court-sponsored program is going to be like a 30-minute evaluation, and that's not really going to touch on the issues. Nothing wrong with getting some extra counseling, a separate evaluation to show the judge that you're taking this seriously and you're really taking steps to help whatever issues may be there, which will go back to help you with the issues we mentioned a moment ago about protecting your rights to your children and being at their events and things like that. As I said, you have the right to file a reciprocal restraining order. You have the right to file a criminal complaint if there is merit to it, if there's merit to it. I never obviously recommend that you go out and file a bogus one. Not only is it unlawful, but it will count against you because it will be discovered. The thing about family court judges, I'll throw in real quick here, is that they've seen so many of these that they know right away when you come up there and tell your story what happened, because they've heard it a dozen times. It's not anything new to them. So my computer screen just quieted down, so I'm afraid I'm hoping I don't lose my PowerPoints before we get off this. And consider civil restraints. I'm not going to go into the civil restraining order in this because it's complex, but it is a very effective method of resolving a restraining order. I generally urge it for both sides when I represent either plaintiffs or defendants if the cases are appropriate. But it's something you want to find out about. My other webinar that I did, Divorce and Domestic Violence, goes into a great deal about that. So I'd recommend you take a look at that webinar. It's on my website and my YouTube page. Okay, moving along, continued issues about how to prevent it affecting your civil and parental rights. And again, this is not just for if a final is ordered, in case you're jumping in at this at a different time. This is before, during, and after the receipt of a restraining order. How to prevent getting one, how to handle one if it's issued, and how to deal with things once one may have been issued. Build in certain protections in your settlement agreements if you're doing any kind of resolution in a divorce or a custody matter. You may want, if there is a restraining order, for instance, and then you're getting divorced, you might want to negotiate that one will be dismissed as a part of the settlement, or build in under what circumstances they would consent for it to be dismissed, perhaps a time period that you wait, or another type of counseling or assessment that you get, but try to negotiate to dissolve it. As I mentioned in the very beginning, you can file a motion after 1 year to dissolve a final restraining order, but the plaintiff can dissolve his or her restraining order at any time. So it's something that is helpful in negotiations of a settlement agreement, specifically inside of a divorce case. Limit your contact where possible. I can't say that enough. I've been saying it through the whole webinar. Whether there is a restraining order, whether you're concerned that there's going to be one, if there was one in the past that may have been dismissed, limit your contact. If it happened once, it's going to happen again. If somebody has told you to be careful, it's going to happen, then there's a good possibility, because like I said, I tell people this all the time. Again, record your conversations. I know I'm going to say it till I'm blue in the face. In New Jersey, anybody who's listening outside Jersey can't tell you if that's lawful where you live, so don't do it until you find out. But you can do it in New Jersey if you're a party to the conversation, and only if you're a party to the conversation. So let me be clear about that. And then do whatever you can to have people present, whether it's just at pickup and drop-offs or conversations. Even if you're somewhere else having a conversation that you think is getting heated, make sure that somebody else is around. If you're going to pick up your children or going to get your items or having problems at home, bring somebody with you. It's always good to have an independent third party, not only as a witness, but sometimes they help diffuse a situation in the first place. So you find that you're not even dealing with the problem because somebody was there. Especially if we're talking about a bogus one. It's unlikely that you get a bogus one when there's witnesses around. All right, got to take it. Okay, so I had that thing happen again with my PowerPoint. I don't understand what it is. All right, so steps to take if you've been falsely accused. First of all, speak to an experienced attorney right away. And I'm not saying that because I am an attorney and that I do this. You need to know right away what you can and can't do and what's going to happen. I can't tell you how many times I've had a client who will say something like, I got the restraining order and I called her up and said, what the hell are you doing? And that's a violation. And it's a normal response in a lot of cases because you don't understand the impact and the severity of a restraining order. So you need to speak to somebody who does. If there's a criminal complaint that was issued against you in a municipal court, sometimes it's superior court, usually it's municipal, talk to a criminal attorney. Sometimes a family law attorney can advise you, but usually you want to go to somebody who does criminal. I tell people, go to people who do just what you need, not somebody who dabbles or handles, one or two different things, because you're not going to likely get the best advice or the best experience. If you hire an attorney, make sure that attorney is prepared with all the information possible. Trust me, as much as I love being an attorney and how much I love other attorneys and trust in their skill and experience, not everybody's got the same level of skill. Not everybody prepares the same way. Not everybody wants to be able to take the time because they can't charge their client. Make sure that they have all the information. If there's police reports in the past, get copies of them. It's faster if you can get them and get them to the lawyer. If you have text messages, print them out. Put them on a disk drive or a USB and make copies of them. Emails, again, print them out or forward them to the attorney and ask if he or she wants to print them out. If you have pictures, download them, get them printed out, not using them on your phone. Oh, my battery, how was that? Running low on my webinar here. So I'm hoping that I get through this recording. I'm going to move a little quicker. Phone records, witnesses, print everything out, talk to witnesses that are not protected under the restraining order, and get anything else that might be important to your attorney. Tell him or her everything. Other steps to take. Sorry about that. I got a call coming through on my phone. So again, copy all of your relevant evidence. Back it up if it's electronic so that it's available. Also practice accessing it if it's through your phone. Realize that it's going to be more difficult in court because there's less internet capabilities when you're in a court. Sometimes the reception is poor. Don't discard anything that might be relevant. One, it could be considered destruction of evidence. Also, it might be relevant. Talk to the witnesses and find out if they would be favorable for you and if they'd be willing to come to talk for you. Sometimes they're relevant but don't want to come. Let me just go back. And lastly, if police were involved and witnessed something, you want to have them subpoenaed to appear. The last most important thing, and I say this almost to the lawyers that might be listening to this, or when you go to lawyer, make sure your lawyer prepares you for trial, walks you through the steps that you're going to encounter, takes you through a trial examination, direct and cross-examination, because it's not just a matter of telling the truth, and I've been saying this for decades. It's how you tell the truth. It's your body language. It's your consistency. It's your eye contact. It's whether you remember the date and the day of the week. You don't want to go in there cold and think that just telling the judge is going to be enough. You need to be prepared. You need to feel what it's like to tell your story. So I've been doing this for decades, and I urge any attorney that is watching this and any attorney you talk to that you make sure they prepare you for it. That is the end. I'm going to leave the webinar PowerPoint up to see if anybody who's online has any written questions. I can also turn now, thankfully, to the people that have supported and sat through this webinar, hopefully enjoyed and got some information. See if there's any questions any of you may have. As I said at the beginning, I'm simultaneously broadcasting on Facebook here, my YouTube page here, and then my webinar here. So I got 3 sets of people that may have questions. Hopefully that the information is helpful. Hopefully you never find yourself in the situation where you need to use this information, but maybe somebody that you know will. I'll give it another minute or two, and actually probably another few seconds actually. I'm not seeing any questions, so I want to wish everybody a good night. Most of you watching here and here know who and where I am, so you can always get to me with any other questions. This information, as well as all my other webinars and tips, can be found on my YouTube page, which is Brad Michael Micklin, and all my webinars can be found on my website, which is micklinlawgroup.com. Again, if you like these videos, I appreciate you giving me a quick like and a share. It helps not